Hello everyone, welcome back to our channel. Today I will discuss an extremely important legal issue, how a false or malicious domestic violence case can be quashed by the High Court as recognized by the Supreme Court of India. This video is important for husbands, in-laws and families who are facing false allegations under the Domestic Violence Act. A domestic violence case is filed under the Protection of Women from Domestic Violence Act 2005. Under this act, women may seek protection orders, residence orders, maintenance, compensation and interim relief. However, Supreme Court has repeatedly observed that domestic violence is often misused to harass husband and his families. Can a false domestic violence case be quashed? Yes, a false domestic violence case can be quashed. The Supreme Court of India clearly held that when a complaint is false, malicious or an abuse of proceedings, the High Court has a power to quash the domestic violence case. The quashing powers are exercised under Section 528 of BNSS gives inherent powers to the High Court, so which court can quash a domestic violence case? A magistrate court cannot quash a domestic violence case. Only High Court has the authority to quash the proceedings of false domestic violence cases. The High Court may quash domestic violence complaint or entire proceedings of the case. According to Supreme Court of India, the domestic violence case may be quashed if allegations are vague and general, no specific date, time or incident is mentioned, parties were already living separately and no domestic relationship exists, and also in-laws are falsely implicated without any role. So, what are the common signs of a false domestic violence case? No medical evidence, no independent witness, only emotional or exaggerated allegations, old incidents received after separation, if complaint filed only after divorce or property disputes. These factors strongly supports quashing under Section 528 of BNSS. Then question is, when quashing is not allowed? A domestic violence case may not be quashed if serious allegations are supported by the evidence, medical records proving violence, independent witness, ongoing domestic relationship, if minor children are directly affected. A false domestic violence case seriously affects the families and careers of the people. Under Section 528 of BNSS, a false domestic violence cases can be quashed with the legal strategy, proper evidences and right timely actions. This information is for legal awareness only. For case-specific advice, always consult a legal qualified professional. Thank you.